Here is a rule nobody tells you about getting old. The people who love you start deciding what you can handle before you've said a single word about it. I found that out on my own front porch at 4 in the afternoon on a Tuesday, holding a manila envelope a stranger had just placed in my hands, while my son stood at the bottom of my steps, refusing to look at me. The envelope had my name on it, a case number under it, and inside it, a petition asking a judge to declare me incapable of running my own life. What neither of my children knew, standing there watching me open it, was that I had spent 17 years deciding exactly that question about other people, from a much higher chair than the one they were about to sit in. Welcome to Family Story Archives. Get comfortable. This one is going to take you somewhere. Drop a comment and let me know where you're watching from. Hit that like button and make sure you're subscribed. Trust me, you're going to love it here. My name is Arthur Dunmore. I am 73 years old, and until 3 weeks ago, I would have told you I lived a small life on purpose. I live alone at 214 San Magnolia Bend Road in Richmond, Virginia, in the same brick rancher I bought in 1994 for $41,000, back when Eleanor and I thought that was a fortune. I keep a vegetable garden out back, tomatoes mostly, a stubborn row of okra, and one fig tree I've nursed along for 10 years, despite 2 hard freezes that should have killed it. My other habit, the one that actually takes up my evenings, is pocket watches. I have a workbench in the spare room, with a jeweler's loop and $43 worth of tiny screwdrivers, and I take apart watches other people have given up on. There is something satisfying about a mechanism that stops working, not because it's broken, but because everyone assumed it was. When people ask what I did before I retired, I usually say I was a paralegal, mostly did filing. That's not a lie so much as it's a door I choose not to open. My children have never asked me a follow-up question in their lives, so the door has stayed closed a long time. Eleanor used to tell me, usually with a mix of affection and exasperation, that my silence would either save me or bury me someday, and I always laughed it off, the way you laugh off something you don't yet believe applies to you. I kept my old robe in a garment bag in the hall closet for years, tucked behind the Christmas decorations, and I kept the letter confirming my appointment to senior status folded in an envelope in my sock drawer, in the back corner, under a stack of undershirts nobody has any reason to look through. Marcus went looking through that drawer once, back when he was 17, hunting for cash he assumed I kept hidden somewhere in the house. He never found any money. He also never found the envelope, or if he did, he never thought to open it, which tells you almost everything you need to know about how closely either of my children had ever actually looked at me. I raised 2 children in that house. Marcus is 44 now, works logistics for a shipping company here in Richmond, and has been underwater on a second mortgage since sometime last year, though he's never once said that plainly to my face. Patrice is 41, married, lives 20 minutes away in Glen Allen, and for most of her adult life has followed whatever direction Marcus was already walking in. Their mother, Eleanor, died 6 years ago this October. I scattered half her ashes at the lake house we used to rent every summer, and I kept the other half in an urn on the mantel, which is a detail that will matter later, though not yet. The first time I understood something had shifted between me and my children, it wasn't dramatic. It was a Sunday dinner in April of last year, pot roast that Patrice had brought over already made. The good plates out because it was also my birthday weekend, and Marcus brought up, almost as a joke, over coffee, that it might make sense to add his name to the deed on the house. Just in case, he said. Just so things are simple down the road, in case anything ever happened suddenly. I told him I appreciated the thought, but I had a will, drafted properly, updated 2 years earlier after Eleanor passed, and things were already about as simple as a house and a life can be made to be. He laughed it off, said he was only thinking ahead, said forget I mentioned it. Patrice changed the subject to the casserole recipe, asking whether I wanted the recipe written down since I'd complimented it twice. I noticed, the way you notice a draft in a room before you can find where it's coming from, that Marcus did not laugh with his eyes, and that he glanced, just once, at the manila folder of house paperwork I kept on the side table by the door, the same folder that had sat there, untouched, for 11 years. A week later I found out, by accident, through a neighbor who worked at the county clerk's office and mentioned it to Diane over a fence line, that a quitclaim deed request had actually been submitted to a title company that same month, listing Marcus as a joint owner of my property. It had been rejected quietly for lack of my notarized signature, which I had never given because I had never been asked to give it. Nobody told me this had happened. I only learned about the attempt itself nearly a year later, when Wendell pulled the full paper trail ahead of the hearing, and by then it had already stopped being a surprise and started being a pattern with a beginning I could finally see clearly. The second time was smaller and somehow worse. January of this year, cold enough that my knees complain walking to the mailbox, the kind of cold that makes the whole neighborhood go quiet by 6 in the evening. Marcus called on a Thursday night, and I could hear his television on in the background, muted, the way people leave it running so a conversation doesn't feel as heavy as it actually is. He asked, in a tone that pretended to be casual, whether I'd considered putting the Buick's title in his name, since he was the one who'd end up handling it eventually anyway, and it would just make things simpler if anything ever came up suddenly. I told him the car ran fine, 61,000 miles, serviced on schedule, and I had no plans to stop driving it or to hand its title to anyone. He said, and I remember this exactly, because it was the first time one of my children had ever spoken to me like I was a line item on a spreadsheet instead of a person. You don't need a house this big, Dad, and you sure don't need a car payment we're basically covering. I did not have a car payment. I owned the Buick outright, had for 6 years, and neither of my children had ever contributed $1 toward it. I let that sit for a moment, the way I used to let a courtroom sit with an uncomfortable silence until the person who'd spoken finally heard themselves the way the rest of the room had. Then I said something I hadn't planned to say out loud yet, a phrase I hadn't used since my last week on the bench. Counsel, you might want to sit down before you keep talking. Marcus laughed like I'd made a joke, the kind of laugh people use to close a conversation they don't want to examine any further. He had no idea it wasn't one. Neither, honestly, did I. Not fully. Not yet. Between the car conversation and what came next, there was a smaller moment I almost didn't count as part of the pattern at the time, though I've thought about it 100 times since. Patrice called me on a Wednesday in March, out of nowhere, and asked how I was sleeping. Just that. How are you sleeping, Dad? I told her fine, same as always, and she said, oh, good. Marcus mentioned you'd seemed a little foggy lately, and I want you to notice that this was the first time the word foggy had ever been used about me, by anyone, including myself. I asked her what exactly Marcus had said, and she backed off the subject so fast it was almost its own answer. I didn't think much of it that week. I've thought about it every week since. If you've been listening for a while, do us one quick favor. Subscribe. A lot of people watch without ever doing it, but it costs you nothing, and it means everything to us. Hit the like button while you're at it, and drop your thoughts in the comments. The third time was 3 weeks ago, on a Tuesday, at 4 in the afternoon, when a man I'd never met walked up my driveway with a folder under his arm and asked if I was Arthur Dunmore. I said yes. He handed me the folder and told me I'd been served, and then he walked back to his car without another word, the way process servers always do, like the paper does all the talking they're not willing to do themselves. I stood on my porch and opened it. Petition for appointment of guardian and conservator, filed by Marcus T. Dunmore and Patrice Dunmore Wells, in the Circuit Court of the City of Richmond, alleging that I, Arthur Dunmore, was no longer capable of managing my personal affairs or my property. Marcus was standing at the bottom of my porch steps when I looked up. He'd driven over, apparently, to watch this happen, or maybe to make sure I signed nothing before he could explain it his way. "Dad," he said, "this isn't what it looks like. We just think it's time somebody helps you organize things." I asked him who somebody was. He didn't answer that. Patrice's name was right there on the filing, so I already knew. I want you to sit with that for a second, because I did. 58 years old inside. If you go by how a person actually feels standing on their own porch, us reading their own children's names on a legal filing that says you can no longer be trusted with your own life. I did not raise my voice. I have never once raised my voice at either of my children, not as toddlers, not as teenagers, and I was not going to start the day they tried to take my name off my own house. I folded the papers back into the envelope, and I said, calmly, the same 6 words I'd said in January. "Counsel, you might want to sit down before you keep talking." Marcus rolled his eyes this time. He still thought it was a saying. He had 3 weeks left to find out it wasn't. That night, my neighbor Diane Okafor knocked on my door before I'd even called her. Diane is 68, spent 31 years as an ICU nurse at VCU Medical before she retired, and she has lived 2 houses down from me since Eleanor was still alive. She said she'd seen the process server's car from her kitchen window, and she wasn't leaving until I told her what was going on. I showed her the petition. She read it twice, standing in my kitchen with her coat still on, and then she said something I hadn't expected. "Arthur, does Marcus actually know what you used to do for a living?" That question matters more than it sounds like it should. Because here is the thing about my life that my own children have never once asked about closely enough to learn. I was not a paralegal. I was, for 17 years, a federal magistrate judge in the Eastern District of Virginia, appointed in 1998. And after I stepped back from full active duty in 2015, I stayed on as a senior status advisor, sitting occasionally on cases when they needed an extra hand, mentoring newer judges, until I finally let that go 2 years ago. My children were adults by the time I took the bench. They were building their own lives, not paying attention to what their father actually did all day at an office they never visited. I never corrected the assumption once it took root, because Eleanor liked our quiet life and I liked it too, and there seemed to be no reason to make a production out of a job. I kept my old robe in a garment bag in the hall closet. I kept my acceptance letter to senior status folded in an envelope in my sock drawer, the same drawer Marcus rifled through looking for cash back when he was 17 and never found any, and apparently still assumes holds nothing worth taking seriously now either. Diane sat down at my kitchen table that night and said quietly, "You need Wendell Cho." I hadn't heard that name in years. Wendell had clerked for a colleague of mine back in 2001, before he went into elder law, and Diane happened to know his sister from church. She called him herself, right there at 10 at night, and by the time she hung up, Wendell had agreed to take my case and he'd told her something I didn't fully understand yet. He said the moment he saw my name on the filing, he stopped what he was doing and called Diane back within the hour. I didn't know what that meant. I would find out. Wendell came to my house 2 days later. He's 52, 24 years in elder law. The kind of lawyer who takes notes on a yellow legal pad because he doesn't trust anything he hasn't written down himself. He sat across my kitchen table, the same table where Marcus had once eaten every dinner of his childhood, and he asked me one question before anything else. Judge Dunmore, do you understand why they filed now, specifically now, and not a year ago or 5 years from now? I told him about the birthday dinner 3 weeks before the petition, the one where I'd mentioned, almost in passing, that I'd run into some old friends from the bench at a retirement luncheon. I hadn't explained what that meant. I never do. But Marcus had gone quiet at the table that night in a way I noticed and didn't think much of at the time. Wendell nodded slowly. He said, "They got scared you were about to involve real lawyers, so they tried to get there first." Wendell asked gently whether I knew anything about Marcus's finances. I said no, we didn't talk about money. We never had. He said that was about to change, because guardianship petitions rarely come from nowhere, and he wanted to understand the pressure Marcus was under before we walked into a courtroom blind. He pulled, with my permission, the public county records on Marcus's house on Featherston Lane. What came back took 2 days to fully assemble. Marcus had refinanced once in 2022, then taken out a home equity line of credit in late 2024, and by this spring he was 71 days behind on that second loan, with a notice of default filed with the county in April, the same month he'd first floated the idea of the deed. I had not known any of that. My son had never once told me he was in financial trouble. He had only ever told me I was. Then came Harold. Wendell mentioned him almost as an aside, a client from 3 years earlier, an 81-year-old widower in Chesterfield whose son had filed nearly the same petition, almost word for word, down to the missed dentist appointment. Then came Rosalind, a similar case in Henrico. Then came Al in Petersburg, whose daughter had used a single slip of the tongue at a funeral as the entire evidentiary basis for a filing. By the end of that conversation, Wendell told me, in 24 years of elder law, he'd seen this exact pattern 11 times, and 8 of the 11 families involved a child who was, at the moment of filing, either behind on a mortgage or facing some other financial cliff they hadn't disclosed to anyone, least of all the parent they were petitioning against. I asked him what happened to the other 3. He said those were the ones where the parent actually did need help, and where the family, to their credit, got that help without ever needing a courtroom to force it. The difference, he said, almost always showed up in whether the child called a doctor first or a lawyer first. Marcus had called a lawyer. The guardianship filing named a court-appointed evaluator, a geriatric psychiatrist named Doctor. Louise Faraday, who would conduct an independent competency evaluation ahead of the hearing. Marcus and Patrice's attorney had submitted, alongside the petition, a stack of what they called supporting concerns. I read through them at Wendell's kitchen table with him beside me. Most of it wasn't lies exactly. It was worse than lies, because it was true facts arranged to say something false. I had, in fact, forgotten a dentist appointment in March. I had, in fact, once called Patrice by her mother's name at a family gathering, a slip that lasted half a second, and that every person over 60 has done at least once in their life about someone they loved. I had, in fact, driven 11 miles out of my way one afternoon because I was thinking about something else and missed my turn. None of that is confusion. All of that is being 73 years old and tired sometimes. but strung together in a legal filing by people who wanted a particular outcome. It read like the first chapter of a decline. I sat there and felt something colder than anger. I felt the specific, quiet fury of a man who has spent his whole career watching other people's families do exactly this to each other, and never once imagined his own would learn to do it to him. Dr. Faraday's evaluation was scheduled for the following Thursday at 10 in the morning, in an office on Grove Avenue I'd passed 100 times without ever needing to walk inside. Wendell told me not to prepare anything, not to rehearse answers, not to try to perform competence for her, because performing was the one thing that would read as suspicious to someone trained to notice it. Just be yourself, he said. If they're wrong about you, being yourself will prove it faster than anything I could coach you to say. If you've been listening for a while, do us one quick favor. Subscribe. A lot of people watch without ever doing it, but it costs you nothing, and it means everything to us. Hit the like button while you're at it, and drop your thoughts in the comments. Here is what nobody tells you about a competency evaluation. It isn't one test. It's an hour and 40 minutes of small, patient, deliberately unremarkable questions, the kind that feel almost insulting until you understand what they're actually measuring. Dr. Faraday asked me to name the current date, which I did. She asked me to recall 3 unrelated words after a 10-minute delay, which I did, all 3, in order. She asked me to explain, in my own words, what the guardianship petition alleged and what it would mean for my life if granted. I told her plainly. It would mean my son and daughter would control my finances, my medical decisions, and where I was permitted to live, and that I would lose the legal right to object to any of it without a separate, harder legal fight to get that right back. She wrote for a long time after I said that. Then she asked me something I hadn't expected. She asked what I used to do for a living, and I told her the truth for the first time in this whole ordeal. Not the paralegal line I gave strangers, but the real answer. 17 years on the federal bench. She looked up from her legal pad and set her pen down slowly. She asked one more question before we finished, one that has stayed with me since. She asked, "Do you think your son believes what he wrote in that petition, or do you think he needed it to be true?" I told her I honestly didn't know, and that not knowing was its own kind of grief, separate from the grief of Eleanor. Separate from anything I'd expected to feel at 73. She wrote something down, closed her folder, and told me the full written evaluation would take 4 to 5 business days, which put it right at the edge of the hearing date, close enough that Wendell would need to file a request for the court to accept it on an expedited basis. Diane drove me home from that appointment, and on the way she told me something she hadn't mentioned before. The circuit court clerk's office required a rush records request to pull the full history of a prior, related filing Marcus's attorney had referenced but not attached, a 2024 letter where Marcus had once tried to add himself to my deed through a quiet quitclaim request that I'd never signed and, it turned out, never actually seen at the time it was filed with a title company. Only rejected because the request required my notarized signature, and I hadn't provided one. Standard processing on a request like that takes 10 business days. The hearing was in 6. Diane paid $340 out of her own retirement income that afternoon for the rush fee, without asking me first, because she said some things can't wait on paperwork's schedule. I didn't find out about that payment until Wendell mentioned it to me later, almost in passing, and I sat with that fact longer than I sat with almost anything else in this whole 3 weeks. My oldest friend since Eleanor died spent money she didn't have to spare so that a piece of paper about my own life would arrive on time. My own children hadn't spent a single dollar trying to understand me. They'd spent legal fees trying to control me instead. In the days between Dr. Faraday's evaluation and the hearing itself, Wendell walked me through exactly how a guardianship case like this actually gets decided, which is not, he said, the way most people imagine it. He told me judges in these cases are trained to weigh a specific, narrow question: whether the respondent can manage his own affairs and make his own decisions, not whether his family finds him convenient, not whether he's slowed down, not whether he occasionally forgets a dentist appointment the way every busy person over 60 occasionally does. The law, he said, is built to protect people who genuinely cannot advocate for themselves anymore, and it is meant to be difficult to invoke against someone who can. That difficulty, he told me, is not a loophole. It is the entire point of the statute, because the alternative, a world where families can strip a parent's legal autonomy on the strength of a single awkward Thanksgiving conversation, would be a far more dangerous world than the one we actually live in. He also told me something that stuck with me longer than almost anything else he said that week. He said most of his clients in these situations never get the chance I was about to get. The chance to walk into a room and have the truth simply arrive on its own, undeniably, in front of everyone who needed to hear it. Most of his clients spend years afterwards still being quietly treated as diminished by family members who were never forced, by circumstance, to confront how wrong they'd been. I asked him what happened to those clients. He said some of them rebuilt the relationship anyway, slowly, without ever getting a clean vindication. Others simply lived out the rest of their years being underestimated by people who loved them, which he said was its own particular kind of loneliness, quieter than the guardianship fight itself and longer lasting. The records came back 4 days before the hearing. They confirmed what Wendell suspected: the 2024 quitclaim attempt. The January pressure about the Buick's title, which Marcus had in fact also tried to formalize through a used car dealership's title transfer service, an attempt that failed only because Virginia law required my physical signature at the DM fob, which I never gave. 3 separate, documented attempts across roughly 14 months to gain financial control over my life before this guardianship petition became attempt number 3. Dressed up in a courtroom instead of a title office. 2 nights before the hearing, Patrice called me alone, without Marcus on the line, which had not happened once in the 3 weeks since the petition was filed. She asked if she could come by. I said yes, mostly out of curiosity about what version of her would walk through my door. She arrived at 7, still in her work clothes, and she sat at the kitchen table without taking her coat off, the way people sit when they haven't decided if they're staying. She told me Marcus had shown her the mortgage numbers for the first time that week, after months of hiding them from her too. She said she'd signed onto the petition because he'd told her it was about my safety, and that she was only now understanding it might have been about his. She asked me point blank whether I had ever actually been forgetful, whether any of it was real, even a little. I told her the truth. I had missed 1 dentist appointment. I had called her Eleanor for half a second at her cousin's engagement party, the kind of slip every person who has loved someone for 40 years makes eventually. I had gotten lost once, for 11 minutes, thinking about a case I used to argue, on a road I've driven 1,000 times. None of that, I told her, is the same thing as needing someone else to hold my checkbook. She sat with that a long time. Then she asked the question I'd been waiting 3 weeks for someone in my own family to ask. She said, "Dad, what did you actually do before you retired that you never talk about?" I almost told her. I had the words ready, but I stopped myself because some truths land better in a room with witnesses than they do across a kitchen table where they can still be quietly disbelieved. And I wanted this one to land where it couldn't be taken back. I told her gently, "You'll find out Tuesday." She looked at me the way she used to look at me when she was 9 years old, and I wouldn't tell her what was in a wrapped box before her birthday. Some things about a person, it turns out, never fully leave, no matter how many years and lawyers get stacked on top of them. The hearing was set for the following Tuesday, 9 in the morning, Circuit Court of the City of Richmond, a courtroom I had not set foot in since my retirement luncheon 2 years earlier. Wendell asked me the night before if I wanted him to inform the judge ahead of time who I was, professionally, so there'd be no surprise in the room. I told him no. I wanted it to come out the way the truth usually does in a courtroom, which is to say, on its own schedule, in front of everyone, once and only once. Tuesday morning, I wore one of my 3 cardigans, the gray one, because I did not feel any need to dress like a man defending himself. Marcus and Patrice arrived 9 minutes before the hearing with their attorney, a younger man carrying a leather folio, and Marcus would not look at me in the hallway outside the courtroom. Though Patrice did, for just a moment, something flickering across her face that I couldn't yet name. Diane sat in the second row behind me, in the same wool coat she'd worn the night she first read that petition at my kitchen table. Wendell sat beside me at the respondent's table, my table, his yellow legal pad open to a clean page, and across the aisle Marcus and Patrice sat with their attorney, who opened with a summary of concerns that sounded, out loud, in a courtroom, thinner than it had on paper. He walked through it carefully at first. He described a man who had, in recent months, shown signs of memory lapses, isolation, and what he called diminished insight into his own daily needs. He referenced the dentist appointment. He referenced the name slip at the engagement party. He referenced, with a gravity that struck me as almost theatrical, the 11 minutes I'd once spent lost on a road I've driven 1,000 times, as though 11 minutes were a diagnosis instead of a Tuesday. Wendell did not object once. He let every word land exactly as weak as it actually was, because he'd told me the night before that overcorrecting too early only makes a room defensive. "Let it breathe," he said. "Let them finish digging before you hand them the shovel back." Then the attorney called Marcus to the stand, and Marcus stood, buttoning his jacket, and for a moment I watched my son try to find the version of himself that could say this out loud in front of a judge and a room of strangers. He said the things he'd rehearsed, about wanting to help, about how hard it had been to watch his father slow down, about how none of this came from a bad place, and then, reaching for something that would close the argument the way he must have imagined it in the mirror that morning, he said the sentence he could not take back. "Your Honor, Dad's confused. We'll handle everything now. We just want what's best for him." The judge presiding was a woman I did not recognize by sight at first, 40-something, sharp-eyed, new enough to the bench that I hadn't crossed paths with her during my own active years. Marcus's attorney walked through the petition's claims. Missed appointments. A moment of name confusion at a family gathering. A pattern, he said, of increasing forgetfulness and isolation that made independent living a genuine risk to my safety and finances. Marcus, when called to speak, stood and said the sentence that would end this hearing, though none of us in that room except me and possibly the judge yet understood. It would. He said, "Your Honor, Dad's confused. We'll handle everything now. We just want what's best for him." The judge looked up from her notes. Not at Marcus. At me. And she said, slowly, in a voice that had gone quiet in a way that made the entire courtroom quiet with it. "Judge Dunmore, is that you?" I had not heard anyone call me that in a courtroom in 2 years. I said, "Yes, Your Honor. It's good to see you again, Judge Alvarez." Marcus turned in his chair. I watched the exact moment the floor changed under him, before he understood why. The way you feel a bridge shift before you hear the sound of it. The courtroom did what courtrooms do when something shifts that most of the room doesn't yet understand. It went quiet in layers. First the clerk, who glanced up from her keyboard. Then the bailiff, who had been leaning against the side wall and straightened without seeming to decide to. Then the gallery itself, a scattering of people waiting on other dockets that morning, none of whom knew who I was, all of whom could feel that something had changed in the temperature of the room even before they understood the words. Marcus's attorney turned to look at his own client, the way a man looks at someone who has just, without warning, become a stranger to him. Patrice put a hand over her mouth. Marcus himself sat perfectly still, the posture of a man doing frantic arithmetic, behind an expression that refused to move. Judge Alvarez set down her pen and said, for the record, that she had clerked for me during my final 2 years on active duty, that she knew my professional history in detail, and that she would need a moment to determine whether she should recuse herself given that history. She turned a page in the file in front of her, slowly, and asked Marcus's attorney directly whether the petition's supporting documentation had disclosed the respondent's professional background anywhere in its filing. He said no, it had not. She asked why. He said he had not been aware of it. She looked briefly at Marcus, who had apparently also never thought to mention it to his own attorney, and she said, evenly, that she found it a curious omission for a petition built entirely around the respondent's supposed diminished capacity, since a person's professional history, memory, and habits of mind are ordinarily the very first thing a competent legal filing establishes, not the last thing anyone in the room happens to discover by accident. Marcus's attorney asked for a brief recess. During it, in the hallway outside the courtroom, under fluorescent light that makes everyone look older than they are, Marcus finally looked at me, and for the first time in 3 weeks, his voice had nothing rehearsed left in it. He said, "Dad, why didn't you ever tell us?" I told him the truth, the same truth I'd been circling for 3 weeks without saying out loud. I said, "You never asked, Marcus. Not once, not in 20 years. And somewhere along the way, I stopped waiting for you to." He didn't have an answer for that. Patrice stood a few feet away, arms crossed tight against her chest. Not because she was angry, I understood later, but because it was the only way she could keep herself from visibly shaking. Wendell stood beside me, quiet, letting the silence do the work he'd told me it would. And I said, one more time, not cruelly, just because it was finally true in the way it had never quite been true before. "Counsel, you might want to sit down before you keep talking." And this time, finally, he did. He sat down on a hallway bench outside a courtroom that had just, in about 90 seconds, rearranged everything he thought he understood about his own father. And he put his head in his hands, and I stood there and let him have that moment without rushing to fill it. Because some moments a person has to sit inside fully before anything on the other side of them can start to be real. Judge Alvarez recused herself formally that morning, and the case was reassigned. But Dr. Faraday's independent evaluation had already been filed with the court 2 days earlier, and it did not need a recognized name to speak for itself. Her report found no evidence of cognitive impairment, no basis for guardianship, and noted, in careful clinical language, that the petition's underlying pattern more closely resembled what she termed financial pressure originating from the petitioners rather than any diminished capacity in the respondent. The reassigned judge dismissed the guardianship petition the following week, on the papers, without a further hearing. I'll give you one sentence for the legal outcome, because the legal outcome was never the part of this that mattered to me. The petition was dismissed with prejudice, meaning it cannot be refiled on the same grounds, and the court noted the filing had been made without adequate disclosure, which closed that chapter cleanly and for good. What happened after matters more. Marcus called me 4 days after the dismissal, and for the first time in longer than I want to admit, he didn't ask me for anything. He asked if he could come by on a Sunday, the way he used to when he was young enough that a Sunday dinner didn't require an agenda. He sat at my kitchen table, the same one Wendell had sat at, the same one that had held every dinner of his childhood. And he told me he'd spent 3 weeks scared, about money, about the mortgage he'd never told me about the notice of default sitting unopened on his kitchen counter for 11 days before he finally read it. He said the fear had made a kind of sense to him at the time that it no longer made sitting across from me in daylight. I asked him plainly why he hadn't just told me he needed help. He sat with that question longer than I expected him to, and then he said something I think was the truest sentence he'd spoken in this entire ordeal. He said, "Because asking you for money would have meant admitting I failed at something you never failed at, and taking your house felt easier than that conversation." I didn't have a clean response to that. I'm not sure there is one. I told him the debt on his house was a smaller problem than the one he'd almost created between us, and that I would help him find a real solution to the mortgage, through an actual financial advisor, not through my deed. He nodded. He has since refinanced through a proper hardship program, on his own name only, and he calls me now most Sundays, sometimes just to talk, which is a sentence I would not have believed 3 weeks earlier. I didn't forgive him standing up and grand. I forgave him the way you forgive most things at 73, quietly, over coffee, watching someone try to become better in real time instead of just saying the word better out loud. There was no single dramatic conversation where everything resolved. There was a Sunday, then another Sunday, then a Tuesday phone call about nothing in particular, and somewhere in the accumulation of small, ordinary contact, something that had cracked began, slowly, to knit itself back together, imperfectly, the way most real repairs actually look up close. Patrice took longer, and I want to be honest that her change has been the more complicated one. She apologized within a week, genuinely, I believe, standing in my kitchen with her coat still on the way she had 2 nights before the hearing, and she has called every Sunday since without being asked. But she still, some days, talks to me carefully, like she's testing whether the ground under our relationship is solid again, checking each sentence before she says it, the way you check ice before you put your full weight on it. I don't fully blame her for that. Trust rebuilds slower than it breaks. I've told her that directly, once, sitting at that same kitchen table, and she nodded like she already knew it. And then she asked me, finally, all the questions about the bench I'd spent 20 years waiting for someone in my family to ask. What kinds of cases? What it felt like the first time? Whether I missed it? I answered every one of them, slowly, the way you tell a story to someone who has finally decided to actually listen. Diane still comes by most evenings, usually with something small, a casserole dish, a crossword she wants my opinion on, though I suspect now that half of those visits were never really about casseroles or crosswords at all. I paid her back the $340 the week after the hearing, though she tried twice to refuse it, standing in my doorway with her hand raised, like she could physically wave the money away. I told her that some debts you settle even when the person insists you don't owe them, because the debt was never really about the money. It was about someone showing up before being asked, on a Tuesday afternoon, without waiting for an invitation, the way my own children had not managed to do in over a year. I still keep Eleanor's urn on the mantel, and some evenings I talk to it the way I never quite let myself do out loud in front of anyone else, not even Diane. I told her, the week after the hearing, that she'd been right, all those years ago when she said my silence would either save me or bury me someday. I told her it did both, in the end, on the very same afternoon, in the very same courtroom, in front of the very same son who once rifled through my sock drawer, looking for cash and found, instead, 30 years later, a truth he never thought to look for. I think about the watches on my workbench more than I used to. A mechanism doesn't stop working because it's broken. It stops because everyone around it assumed it already had and stopped bothering to wind it. My children assumed that about me for longer than I'd like to admit, and I let them, because it was easier than correcting them, right up until the moment easier stopped being an option. I don't regret the years of quiet. I regret only that it took a courtroom, a Rush Records fee, and a woman named Louise Faraday with a legal pad to finally make my own children look at me and see the whole clock instead of just the case it came in. Last Sunday, Marcus asked me, almost shyly, if I'd ever consider telling him about a real case sometime, one from the bench, start to finish. I told him I would, eventually, when he was ready to actually sit and listen instead of half-listening while thinking about something else, which is its own kind of skill a person has to relearn. Patrice asked if she could see the old robe. I took it down from the hall closet that same afternoon, brushed 30 years of dust off the shoulders, and she held it for a long moment without saying anything at all, which told me more than any apology could have. Diane laughed when she heard that detail later and said it only took a guardianship petition to get my own daughter curious about a garment bag that had been hanging 11 feet from her childhood bedroom door her entire adult life. I didn't have a clever answer for that. She was right, and there wasn't much else to say about it. I still wind the watches on my workbench every evening, one at a time, testing the balance wheel until it settles into a steady, even tick. Some nights I think about how easy it would have been for this to end differently, for the petition to have landed in front of a judge who'd never clerked for me, for Diane to have looked out her kitchen window 5 minutes later than she did, for Wendell to have been unavailable that week. None of what happened required me to have been powerful. It only required, in the end, one honest evaluator, one loyal neighbor, and one afternoon where the truth finally had nowhere left to hide. That's a thinner margin than I'm entirely comfortable with, and I think about it more than I let on, even now. If you enjoyed this story, join our community by hitting that like button and subscribing for more real, raw, and family-centered stories. And as always, thank you for being a part of Family Story Archives. I will see you on the next one.